All right. Good morning, everyone. We have a 2-week trial calendar that we're calling today. Trials start a week from Monday, the 14th. Oops, that's not my calendar. And then we also have the week of the 21st if we need it. We'll figure out today what's going to go out starting on the 14th. Position 1 is Nakeem Christmas. Mr. Christmas, are you here?
But I do expect him today. I spoke with him yesterday.
Okay, we'll call that name again. Hey, Colonel, how are you? Do you,
I just want to update you on the inquiry you had,
which I've had lots of inquiries.
John Williams,
Oh, Jai.
Jai.
Yeah.
What happens is once they sentence, the clerk's office put together a sentencing packet, and then we put it on the DOC portal, and they let us know
When they're
we have
ready.
available beds.
Okay. I was just curious, not upset. I just figured you'd want him.
Yeah, it takes at least 2 to 3 weeks sometimes.
That's a long time. That's not good for you guys. Yeah. And so they need room for everyone. Okay. All right.
But I'm gonna follow through as well.
Okay. Thank you so much.
Gordon.
We're good. We're in a great state here and he's doing great. He knew you were coming. See? I called her. I said, I can't find Gordon. Where is he? She came running down here. Mr. Henley. Don't see Mr. Henley.
I'm so expecting Judge. I spoke with him yesterday as well.
Maybe he's commuting with Mr. Christmas. Keandra Logan. Hey, Mr. Logan, hold on one second. I forgot. Where? Wouldn't be a probation, it's a pre-trial. Check with her. Okay. She's great. Okay, thanks. Hey, Mr. Logan. We're gonna hold to get a report from Mr. Apt.
Your Honor,
Okay.
I'm here on the Zoom.
You're on the Zoom.
Good
Excellent.
morning. Good to see you.
Good morning.
We have a plea worked out in that case.
Well, that's timely. Good. Okay. Let me get through calling the calendar and we can start with that. So we'll get you on your way.
Thank you, Your Honor.
You're welcome. Mr. Lim. We weren't sure if he'd show up. Okay. But he may be in a larger car with these other 2 clients of yours. So we'll see. We'll go through the calendar one more time. Jai Williams actually in the house. A little surprising. Down in the basement. We're not bringing him up. That's why the Colonel came. All I had asked was, why is he still here? I didn't need your boss's boss to come down here. But they're just waiting. Apparently they accumulate a number of folks before they have people go to GDC. He was brought over because he's on the calendar, but he was not brought up. You're welcome. Mr. Dandridge is here and we brought him up in the just in case. So he's here. Then we've got Brenton Dennis.
Good morning, Your Honor. David Bass, Mr. Dennis.
Hey, Mr. Bass. Mr. Abate is coming.
Yes, he'll be here shortly.
All right. He is thank you, your counterpart in this case. And we need to figure out what's going on with the case.
Thank you.
So I guess when he gets here, you can let me know.
Absolutely.
I'll know when he's here, but then you'll be able to let me know what your announcement is. Okay, great. When did you come onto the case?
Oh, about a month and a half ago.
So you've had plenty of time to get ready.
Good to go.
Excellent. Okay. Mr. Perry is here and Ms. Hightower. Good morning, both of you. So Ms. Hightower, any idea if Ms. Taylor's going to be here today?
Said you put in something,
I think that's right. I'll check when we get through the calendar and we'll figure that out. And you, Mr. Perry, how about Ms. Gladden? Where's Ms. Gladden?
It takes, cause she's in traffic, she's trying to get here.
Okay, then you sit tight and we'll figure that out. So Ms. Taylor did not file a leave of absence in your case, but I do remember the last time you and she and I and the prosecutor were talking, she said something about having leave. It's just not in your case. So I'm gonna have you sit tight while we confirm that, okay? And then Ms. Gladden will get here and we'll talk about that. Ayanna Powell?
Good morning, Your Honor.
Good morning, Mr.
I
Melnick.
think with Ms. Powell this morning, but obviously she's not here. She is on her way. I think we are close to a possible resolution in this case.
All right. Well, we'll all talk once Ms. Powell gets here. I don't know if you received a copy of the consolidated calendar. You're super popular.
I know.
Okay.
We're looking on the calendar.
Well, Judge Emerson sent me an email saying, maybe I'll meet Mr. Melnick. I said, I don't know. He's popular in a lot of jurisdictions.
I was gonna say, I've got a murder trial in Buchanan County, 2 defendant murder trial that's going out the 21st. So it's pretty unlikely I'll be available.
We'll see. We'll see which is the oldest of the cases. And then we have Ms. Favors. Ms. Favors is here. They hadn't been able to bring her up yet. So if you need to speak with her, let Deputy Gordon know and we'll make sure she's brought up.
Thank you, Judge.
Okay. And then add on, Mr. Frazier just cruised in. Good morning, Mr. Frazier. And then Mr. Dandridge, part 2. So he's here. So we're waiting on Christmas and Henley. Mr. Logan is here. Sounds like we can do that plea right now. And then when Mr. Abate gets here, we will talk about Brenton Dennis. Hopefully Ms. Gladden gets here soon too. Anyone here who didn't hear their case called? No? Mr. Apt, you ready to go?
I am, Your Honor.
Ms. Dilligard, are you ready?
Yes.
All right, Mr. Logan, if you'd come up to the podium here with the springtime M&Ms. And can you, Mr. Logan, adjust that screen in front of you? Just bend it up a little bit so Mr. Apt can see. There you go. Thank you. All right. Ms. Rivers, are you ready?
Yes, I am. Good morning.
Good morning. So are you ready, Ms. Dilligard? You are. Excellent. Okay, let's go on the record. This is position 3 on our trial calendar. State versus Logan, 22 SC 185229. Mr. Logan is standing here in court. Mr. Apt, his lawyer, is appearing virtually, and Ms. Dilligard is here. Mr. Logan, before I let Ms. Dilligard take over the proceedings, I need to get on the record that you are okay moving forward with this plea with Mr. Apt appearing virtually. You have a right to have your lawyer right next to you. Virtually, he's next to you, but you can't just lean over and ask him a question. You all right with that?
Yes.
Okay. Will you let me know if at any point you want to speak to him privately?
Yes.
Because if that comes up, you can just step outside. I'm sure he can give you a phone number and you guys can speak privately. I also need you to let me know if you've just got a general question that doesn't need to be confidential so that either he or I can answer that. Will you do that?
Yes.
Yes. Okay. When you're ready, Ms. Dilligard.
Mr. Logan, please raise your right hand. Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true and correct legal name for the record.
Keandra Deshaun Logan.
Mr. Logan, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not been given to?
No.
How old are you and how far have you gone in school?
23 and 11th year.
Can you say how far you've gone?
11th grade year.
Okay.
Do you understand that you have been charged with the following offenses? It's 1 count of armed robbery, count of aggravated assault, 1 count of aggravated battery, false imprisonment, and possession of a firearm during commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment against you, including the facts and circumstances related to those charges?
Yes.
Would you like any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
We do.
Mr. Logan, do you remember having been arrested on these charges?
Do I remember being arrested for him? Yes.
Has your attorney advised you of the minimum and maximum sentence for which you are pleading guilty to today? So the armed robbery, which we're reducing to robbery, the range is 1 to 20 years.
Yes.
Aggravated assault is 1 to 20 years. Aggravated battery is 1 to 20. False imprisonment is 1 to 10. And possession of a firearm during commission of a felony is 5 years consecutive.
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to reduce the armed robbery to robbery pursuant to OCGA 16840. This total sentence is 10 to do 5. And then the 5 for count 5 is probated but suspended. That makes sense?
Probated or suspended?
Suspended.
Suspended. And that's consecutive to the, whatever the,
10
one of
serve.
yours is going to be 10 serve 5, and then it's plus 5 suspended?
Yes.
Okay.
And the conditions is no contact with the victim, no contact with any of his co-defendants, and a stay away from the incident location.
Okay.
Is that your understanding of the recommendation?
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
You understand that the court has the right to sentence you to the maximal possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Logan, how do you plead to the reduced charge of robbery, aggravated assault, aggravated battery, false imprisonment, and possession of a firearm during commission of a felony in indictment number 22 SC 185229?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition?
Yes.
Judge, if this case were to proceed to trial, the evidence would show that on July 19th, officers responded to a robbery scene where the victim, Cullen O'Gara, Ogara, was found in the back of an ambulance after his neighbors called for help. The victim stated that he advertises on social media that he sells clothing and sneakers to potential customers. A few potential customers came to his house to purchase those sneakers. The victim had coordinated with one of the co-defendants, Charles Duke, to come to his house and to purchase and to look at the sneakers for potentially purchasing them in the future. Defendant Duke, Logan, and the other co-defendant, Mr. Grulon Panigua, who's already pled guilty in this case, came to his house, but they instead refused to accept. He did not accept payment over Cash App. That was the way that they were trying to pay. There was a disagreement, and then the defendants took out a firearm and zip tied his hands and his feet. They pistol whipped him, and they left with $15,000 worth of clothes and shoes, the victim's cell phone, and some cash from his nightstand. The men also told the victim not to call the police because they knew where he lived, and they left in one of the defendants' cars. They were able to get the license plate, track that to one of the co-defendants. That co-defendant then gave a proffer in the case implicating the other two co-defendants. I believe the last co-defendant is in judicial hold at this time.
He is AWOL.
Yes.
Yes.
And we are all looking for him. But all of this occurred in Fulton County, Georgia. I have had the opportunity to speak with the victim multiple times. He's comfortable with this negotiated plea. I expected him to maybe show today, but I don't see him. But otherwise, he is comfortable with the plea, and he's happy with the way that the case has been negotiated.
And can you tell me, we will have a stay away from the incident location. That would have been at the time his apartment, or, I mean, his address can remain confidential, but I'm wondering if you want to just have a no contact with the victim.
Let's just do a no contact with the victim.
Okay, we'll do that. All right. Are you seeking restitution?
We are not from this country.
Okay. Good morning, Ms. Jackson.
Good morning, Your Honor.
How are you this Thursday?
I'm great. Yourself?
I'm feeling a little tariffed, but that's just me. If you would share with me any criminal history information you've got on Mr. Logan, I'd appreciate that.
Okay. There are 2 cycles. The last arrest was February 6, 2025 in Gwinnett County for possession of Schedule 1 controlled substance and a DUI. There was no disposition for that arrest, and there are no convictions listed, Your Honor. Nothing in addition.
Can you give me that date again?
Yes. February 6, 2025.
Interesting. Okay. Thank you. Mr. Act, I'd like to hear from you about Mr. Logan, this case, and how it didn't hit our radar that Mr. Logan got arrested in Gwinnett. I guess he got a couple bonus months to be out and about.
Well, Your Honor, I'm not sure I'm going to be able to speak with great knowledge about the Gwinnett matter other than to tell the court that there's no disposition of that case. And, you know, there was never a motion to revoke his bond. So he's still presumed innocent in that matter. He does not have any prior felonies. I don't think he has actually any prior criminal history of any kind other than that pending Gwinnett case. So he is first offender eligible. And he completed the 11th grade. He was employed full-time, Your Honor, with Amazon. But when this incident happened, Amazon initially let him keep his job, but there were obviously, we've been to court a few times and they were not all that thrilled with the court schedule. So they had to let him go. He does have family that's present in court. I know his mother is here with him. And I've been in constant communication with my client and his mom over the last several years about this case. And we're humbly before the court, asking the court to accept the negotiated plea. I don't know if the state is going to oppose first offender, but he's eligible. And so if the court would entertain that, I think that would give Mr. Logan a second chance to, make something of himself and do good in the world.
Okay. Thank you, one, for your continued and persistent representation of Mr. Logan. I know this case overlapped with another case of yours that consumed much of your time, but you, Mr. App, made yourself available when we needed to handle certain things with Mr. Logan's case. And so hopefully he appreciates that as well. What are your thoughts, Ms. Dilligard, about first offender?
Judge, through negotiations, there were some other factors that Mr. Logan declined, and because of that, we had a conversation that we were not going to be consenting to. We would be opposing first offender. I do also want to highlight for the court that it's this defendant that the victim said is the one who actually pistol whipped him, which caused him to have to get multiple stitches in his head. So the state would be opposing first offender because of that.
Okay. Mr. Logan, you don't have to say anything at all, but you get a chance to be heard as well if you want. You can say, look, my lawyer said what needed to be said. But if there's anything you want to add, or if you have any questions about anything we discussed, I'm happy to try to answer those questions.
No, I ain't got none.
Okay. You got any idea where Mr. Burkott Dukes is?
Who that?
The third defendant?
Oh, no.
Charles?
I don't know none.
Don't know nothing. Okay. All right. Mr. Logan, this may seem like a tough outcome for you, but the state's agreement to reduce the armed robbery to robbery is pretty significant. I'm sure Mr. App told you a lot about this, but armed robbery has a mandatory minimum 10 years. And the sentence that you've negotiated, if I go along with it, is only 5 years in custody. Almost as important, those are parolable years. Whatever you got under an armed robbery sentence would be they call it to the door. Doesn't matter how great you did while you were in custody, you'd serve every day of that sentence. But robbery and these other offenses to which you're pleading guilty are parolable. That doesn't mean you'll get parole. I don't want you to leave here thinking, great, I'm out in 20 minutes. But given your lack of criminal history, assuming that you stay out of trouble while you're in custody, you will be someone that the parole board will be looking at. And they couldn't look at you at all if it was armed robbery. So you're young, and a 5-year prison term probably seems infinite, but Mr. Apt has negotiated effectively on your behalf. First offender, has Mr. Apt talked to you about first offender?
Yes.
Okay, tell me what you think first offender does.
Well, honestly, I don't know. I ain't gonna lie. I just know about the other deal. I ain't trying to take that.
Okay.
I don't take that. I'm just gonna take the time.
You just want to do what you're doing.
Yes.
Your Honor, in full disclosure to the court, there was a negotiation for even less time where the state was going to consent to first offender, but it would require testimony. And and just to let, I know the court doesn't want to get involved in that, but Mr. Logan has a family member who did exactly that a few years ago in Fulton County, who cooperated against his co-defendants. And then it's Mr. Logan's cousin. And then subsequent to that cooperation, he was murdered by the co-defendant. So he's very hesitant, and that's why he's being quiet and not very verbose today. But I assure the court, he understands. I've gone over what first offender treatment does for him,
Yep.
benefits and the burdens. And we are requesting it. I appreciate that the state is opposing it, and I understand why.
Right. Okay. I understand that. And Mr. Logan, I'm sorry for you and your family's loss in that other situation.
Thank you. That
That probably greatly influences how you think about a situation like this. And so I appreciate Mr. Apt flagging that. Mr. Logan, I find there's a factual basis for your plea that if this case went to trial and Mr. O'Gara had to come in here and relive it and talk about it, that with a license plate, et cetera, and potentially the testimony of one of your co-defendants, a jury could find you guilty of all of these crimes. I also find that your plea is knowing and voluntary. Voluntary means that no one's forcing you to do this. You might not be super excited about it, but no one is saying, your family's in trouble if you don't do it or anything like that. And knowing means you've understood the things that you and I and Ms. Dilligard and Mr. Apt have been discussing. Is that a fair statement?
Yes.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that when you're on probation or parole, you may be on both for a while. If you have a minor violation, you and probation will figure out what the results are of that. But if it's more serious, you get arrested again, something like that, that comes back to me. Mr. Apt, can someone in my office sign the indictment on your behalf?
Please and thank you, Your Honor.
Okay, you're welcome. Ms. Dilligard?
Yes, Judge.
And Mr. Logan, we don't hand sign lots of things anymore. We do electronic signatures. Is it okay if we sign the indictment indicating your guilty plea to that reduced charge of robbery and the other crimes?
Yes.
Okay, great. Mr. Logan, I will follow the negotiated resolution in this case, which means as to count one, which has been reduced to robbery, you are being sentenced to 10 years to serve 5 years. You may have spent a little time in custody or a lot of time in custody before you bonded out. You'll get credit for all those days. Those go towards the 5. The balance will be probated. Same sentence for counts 2, 3, and 4. So 10 serve 5, balance probated. Count 5 has to run consecutive to count 1, and it has to be 5 years, but I can probate it or suspend it. I will suspend it, which means the sentence is out there, but there's no probation. You don't have to check in with anyone. But it also means that if you violate the conditions of that suspended sentence, and there's only going to be one, and that's that you obey the laws of Georgia and the other states. But if you were to get arrested during those last 5 years and the state learned about it, they could seek to revoke those years as well. So it's 5 years custody, 5 years probation, 5 years suspended. That gets you to the 15 that were negotiated. Special condition of probation number 1 is no contact with Mr. O'Gara, the clothing salesman. And then number 2, no contact with either of your co-defendants. Do you have any questions about any of that?
No, sir.
Okay. Mr. Apt, anything else on behalf of Mr. Logan?
I didn't quite catch if the court was going to grant first offender or not.
No, you caught it. I didn't. I didn't say that. So that's not part of the equation. Ms. Dilligard, anything else from the state?
Nothing further from the state.
All right. Mr. Logan, you're going to go with Deputy Gordon. Thank you. Thank you, Mr. Apt.
Thank you, Your Honor. Your Honor, that's all my business. May I be excused?
Yes, off to your next assignment.
Good to see you. Thank you.
Bye-bye.
And it's a court notice, second edition for.
Thank you. I've seen people come in. I saw Mr. Abate get here. So I'm going to call roll again to see Mr. Bass, our attendance taker. All right, let's try again. Mr. Christmas, did you make it? Mr. Christmas is here. All right. Ms. Wood, what's the announcement in Mr. Christmas's case?
We are ready, but we're also working on something and I need to speak to him.
Oh, right. Was there an accountability court angle? Was there not part of what this would be? Okay. All right. So why don't you give me an announcement? Mr. Christmas, I need you to stick around. Do not leave. You can go use the restroom, but don't leave the building until we all talk about what's going on with your case. Okay? Great. How about Mr. Henley? No. All right. We'll do a bench warrant on Mr. Henley. Mr. Lim, we'll do a bench warrant. Mr. Dandridge remains Mr. Dandridge. Mr. Bass, did you and Mr. Abate have a chance to talk, or do you need more time to talk?
Yeah, either best.
Sounds like you haven't spoken yet. All right. When I finish this little roll call, why don't the two of you talk a little bit about where things are and where they aren't? Mr. Perry, I don't see Ms. Gladden yet, so I'm sure she's working her way here. You're going to need to sit tight till she gets here, all right? Ms. Powell, did Ms. Powell make it?
So she, just texted me, wrote as you said that 10 minutes away.
Okay, well, we'll wait. Ms. Favors remains in the building, and she'll get brought up at some point. And then on our supplement, we still have Mr. Frazier and Mr. Danders. Did anyone else come in?
Have you called Dennis yet?
Yes, and that's Mr. Bass, meaning that's the lawyer, and he is going to speak with the prosecutor, and then I'll get their announcement. Okay, but Mr. Dennis is here. I just need to know from the lawyers whether they're good to go week 1 or week 2, or if it's a plea or a dismissal or whatever's happening. So it sounds like people need to talk a little bit. I didn't hear anyone else say, yes, I have a plea ready.
I think she was released, but I don't know if the attorneys know anything about it, so we just might want to.
Call that one too. All right. Ooh, that looks like the restitution.
Yes, Judge.
All right, Mr. Frazier.
Yes.
Ms. Recky is on for a probation revocation calendar, but she may be gone. I don't know if you got any update on her.
So we had referred her to BHTC, but I think she might have been released.
She was released.
And she would have been released in how if there was a probation warrant?
That's a great question, Judge. Ms. Ross saw her like 2 days ago or 3 days ago.
I blame Ms. Simpson.
Our warrant was still good, but somebody to get out of process.
Oh, I'm sure it was. Yeah, but I don't understand then how, well, Lister is still in custody. Let's see. It has a booking number and Lister is still in custody. Did you lose her?
I wanted to say she was released, but.
Okay, and you may have even more current information, but in Odyssey, there's her booking number. She was taken into custody January 4th, and today is her 90th day in custody. Maybe it was her 89th day, and then she got out.
I called her and see if he.
Okay, I mean, we weren't gonna do something today. You know she's not in jail?
Well, no, I don't know, Judge, but she doesn't need to be brought over if she's still there.
Does not.
Does not.
Agreed, right, but we just need to not lose track of her. If she's been released, probably need an explanation why, since there was a hold. And then if she's not, then I guess we need to keep working on that.
Thank you, Judge.
All right, there's a research project for you. So I will step off the bench. I will come back to talk about Mr. Dennis, to get an announcement on Frazier, see what's going on with Mr. Christmas. Maybe Ms. Favors can figure out how to get here. I mean, Ms. Powell. Ms. Favors is here. Yeah, good point. Ms. Powell, and we can wrap up, it sounds like, Mr. Frazier's case as well.
Judge, so I do have it's the first money order, and then the second one will be on its way. He's working hard to get that, the rest of the amount. May he be excused, or do you want him to stick around?
Well, unless he's like coming back today with it. What you had told me is that it's end of month or whatever the deadline was. But I guess what I'd want to know is that you're withdrawing the speedy or the state, something before he leaves today, because otherwise next Monday, not a few days from now, but the Monday after, he'd need to be back and we need to go forward. So you just talk about how you want to structure that, whether it's we withdraw the speedy or I don't know we don't dead docket things. It wouldn't be a null pros quite yet, because it sounds like there's one last bit that needs to happen. So talk amongst yourselves, and then just let me know what you're going to do. All right. Okay. I'll be back in 10 minutes because Ms. Powell should have gotten here by then.
Judge, can I take up something real quick that's not on the calendar today?
Uh-huh.
Judge, we've got Ransom that had been scheduled for a probation revocation hearing tomorrow.
Yeah, and then I messed up everyone's schedule.
This is the case where the basis for the revocation was new charges in Early County. We were here maybe 3 weeks ago, and you
I remember Mr. Ransom, right? I know the guy.
So I showed proof to Ms. Dilligard that the new charges in Early County were null prost. So we've reached a consent agreement as to the revocation to revoke 90 days, which is essentially a time served revocation, and return him to probation. Since you're not available tomorrow afternoon, we were wondering if we could just present the consent order. I have the authority to present that in, in his absence. If that's okay with you, we could just do that today.
Sure.
Okay, all right.
They can do that. Mr. Henley just walked in, Ms. Wood.
Oh, I was speaking objection.
Great.
This is it, right?
All right, I will be back in a few minutes and we'll take stock of what's going on. Okay, did Ms. Wood want to speak with her?
Yeah.
Yeah, okay, great.
I sent you an email regarding Terrell Stokes filed a immunity motion.
Yes,
You want to put it in?
no, we'll do it because the timeline is such that we ought to do it. Yes, sir.
She just, let me, she called for, then she knows she had a call from Logan Court, she'll be as soon as possible.
Great, thank you. Seriously?
She's like, you don't remember me now, like, the face isn't jumping out, but I am very kind. She's like, sit my ass, I'm like, you're not married?
Exactly, it's a long list, ma'am.
I'm like, have a good day, man.
Is she, this was this morning?
I'm like walking into the door, we just walk away. I'm like, maybe.
She's looking for it because he doesn't have representation, so I keep putting him motion.
I thought that he had Brandon Lewis.
That came out.
Smart Brandon. Probably got tired of dealing with co-counsel. I know.
So, you know, I can't put it on the calendar.
Nope.
It doesn't have, so I
Right.
keep looking, so maybe that's.
Which is all good. He's earning good time.
We're not like.
Okay.
She's always around though.
Apparently.
Judge, I probably, okay, this last thing.
Hmm?
I'm gonna withdraw the speedy and I just turn over the first money order, so maybe Mr. Grace be released.
Yes.
Okay. I was ashamed. Okay, all right, have a good one. Thank you. Should we just let me know when you're the best, thank you. Okay, perfect, thank you.
I figured I'd mute it. Okay, are you able to bring Mr. Dennis out?
Thank you. All right, we'll bring you out in a minute.
We found Ms. Recky.
Oh,
She's still at ACDC,
okay. Great.
just wasn't brought over. But sounds like that wouldn't have been necessary anyway.
Yes,
So
correct.
she's still around.
Perfect.
Yeah, exactly. Ms. Simpson's just, her job's been saved.
Oh, Lord.
Phew.
Let me ask him. I had not thought about that. Okay, let me talk to him. This one, it's just like a mess.
Hey, Mr. Dennis, why don't you come up to the podium, stand next to Mr. Bass? All right, this is position 7 on the trial calendar. Mr. Dennis, the April trial calendar is a 2-week trial calendar. We've got the week of the 14th and the 21st to try cases. Mr. Bass, have you received all the discovery that you think is out there?
I have received the discovery that the state is obligated to provide. I'm putting the finishing touches on 2 Open Records Act requests. I've been in contact with the Atlanta Police Department and the Sheriff's Office. We've gone back and forth. I should receive, well, I'm certain I will receive everything by the second week, the 21st, probably the 14th, but just to be on the safe side so I can get it, review it, get it to Mr. Abbott in time for him to know what's going on as well. I'm requesting the second week.
Okay, talk to me about open records requests versus if it's in the custody of, say, the sheriff or the Atlanta police, why the state wouldn't be getting it for you? Is it not directly related to the case, meaning like it's a personnel file of a detective as opposed to?
You're reading my mind. It is
Okay.
the personnel file of the detective with Atlanta Police, and it's the background of the deceased.
Okay,
He was wearing a wristband from the Fulton County Sheriff and had other run-ins with the Sheriff's Department that I'm getting those reports from.
got it. And so those are things that the state might not be looking for anyway.
Correct.
You're on the hook for getting them and you're using an ORA request rather than getting a subpoena from me.
Yeah.
Okay. That works for me. Your preference then would be week 2,
Correct.
just to make sure you're able to get from these 2 agencies the things you're looking for.
Absolutely.
Okay. If you would let me know if you run into any issues, and I ask that because if I need to become part of the discussion to dislodge the things, if it's appropriate to, I'm not going to make APD disclose something that they think they have a statutory basis not to disclose. But if it's just slow walking or something like that, I'm happy to get involved so we don't delay things.
Absolutely.
Let me take a quick look here at the indictment. Okay. But otherwise, you're ready to go. You're not waiting on things you think the state is obligated to get you. It's things that are part of your independent investigation.
Correct.
All right. Mr. Body, what's your thought about being ready week 2?
For that only one.
Okay. But you're not aware right now of any scheduling issues for any of your witnesses?
Not at this moment, but I'll be, and where I haven't reached out to the main players that I will today.
Okay, if you would, that would be great. I'm pleasantly surprised Mr. Bass is ready to roll, just because you came in late to the case. But that's great. I was expecting we'd be having a different conversation.
There's a McBurney air about Fulton County. You better be ready.
Well, all right. I wasn't aware of that air, but I'll take it. Mr. Dennis, do you have any questions about what we just discussed?
No.
Okay, you understand then that if things align right, I'm not guaranteeing that we go out to trial the week of the 21st, but Mr. Bass is saying he's ready then, and as long as there aren't any impediments to the state being able to move forward that week, that's when we could handle your case. Any questions about that?
So it's gonna be the 14th or the 21st? Cause he's talking about the 14th.
No, I heard him talking about the 21st.
I heard my lawyer, but I'm talking about him.
No,
Who's him?
I don't know his name.
I'm not following what you're saying.
Who is him?
All right, I think the confusion is he said he'd prefer the second week. The second week, according to the calendar, would be the 14th, but he means the second week of the trial calendar.
Okay.
So that would be the 21st. So we're
I'll make it real clear. If we reach your murder trial on this calendar, it'll be the week of April 21.
Okay.
And if we don't, then we'll bring you back on the next calendar because Mr. Bass isn't going to be any less ready then, and the state will be ready. So it'll be the 21st. Mr. Bass, you'll be getting emails from me. They'll go to Mr. Abate as well with the details of, hey, I need your voir dire by this day, et cetera. Your additional role that won't be on the state will be to make sure, assuming we're a go for the 21st, exactly, is that Friday before through family or however you get to my courtroom, clothing for Mr. Dennis, at least for the first couple days. It may be as the trial goes on, clothing comes for additional days, and that's fine. But certainly for Monday, Tuesday, whatever it is that you and he think he ought to be wearing for court, you'll need to get that to court that Friday.
Understood.
Okay. Anything else on behalf of Mr. Dennis?
Can't think of anything.
All right, Mr. Abate, anything on behalf of the state? Okay. Forecast. I know you've been focused on other cases, and so you're welcome to revise this after you look at it. Length of case.
5 days, we could do it.
Ought to do a Monday through Friday. It ought to fit. Okay.
Monday through Friday, even if it was a Tuesday through Friday.
Okay. Got it. You see if there's anything. Oh, I think I got it. Okay. Do you have any questions, Mr. Dennis? All right, then, assuming it's a go, you'll be brought over on the morning of the 21st to get dressed out, and we'll pick a jury. Thank you, Mr. Bass, for being here. Appreciate it.
Thank you, Your Honor. Thank you. I'll come see you today.
So, Mr. Melnick, I am happy to handle the Mac situation, Mac Ransom. I'm underwhelmed by Ms. Powell.
I understand that, Judge. I have been in communication with Ms. Powell, sorry, she's indicated she's on her way, but I will.
Yeah, that would be like the 6th time she's indicated that.
Yes.
So, no bench warrant till we're done, but there's not much more we need to handle this morning, and then that may help resolve the case.
I will wait and see if she arrives.
Okay.
Thank you.
All right. Ms. Favors is up. All right. Mr. Perry, any update from Ms. Gladden? She's working her way from the other court.
She said she's going work. That's the last day she said.
Okay, maybe she's with Ms. Powell. Did Ms. Wood go back there? She's outside? With what? Okay. So when she comes back in, we'll talk about Mr. Christmas and Mr. Henley. Looks like Lim is gonna be a bench warrant. And that's sort of it. Because Dandridge, you took care of Frazier. What's the, Ms. Dilligard, what's the expectation as to when Mr. Frazier will get round two?
I think it's before the end of April, May.
Okay, all right. Yes, ma'am.
Did you still want me to wait?
No, you're free to go. Yep. We are. I just don't know when. Got to make sure Ms. Taylor will be around. I didn't need to use the warrant for Mr. Logan. After all that. I feel like I've heard of the victim in the Dennis case, but maybe it was just from reading the indictment.
I had the same, initial thought.
Yeah,
But I don't know how.
you couldn't place it. Okay. Ms. Wood,
Yes,
couple questions. On the Frazier case, the expectation is end of the month.
yes,
Okay, so we'll put a tickler in to check with you and Ms. Dilligard. I'm confident that if it's done, you'll be putting a tickler in saying, where's the null pros?
yes, sir.
But we'll do a early May, inquiry. All right. Mr. Christmas, what's the update there? If there is one yet.
It's not resolving today. We are still working. He had brought in some mitigating evidence that I've shared with Ms. Dilligard. And we're still working, still potentially a diversion case. We're just not there just yet, Judge.
What about, are accountability courts part of that diversion?
That was, yes, that's the first offer. And so I had misunderstood and I had conveyed the district attorney's office diversion to him. So now I'm just reworking everything with Mr. Christmas.
Okay, assuming he's interested in the accountability courts, how soon could he connect with the intake team? Or that's something you and he need to talk about
That,
first?
I haven't made a referral yet.
Okay. I had said I was gonna do the math and I haven't yet on the speedy in that case. Because I want to make sure, I know Mr. Frazier's clock, which is why I appreciate you having withdrawn that. But it was, you did January, February, so it'd be March, April. I don't know that we get past the end of I'll have to look again. I
thought we had one more, but I can double check two tracks.
Okay. But today there's nothing more. What should I look for as the next step with Mr. Christmas?
I was going to propose just leaving him on the trial calendar so that keeps the pressure on.
Yes, yes, yes.
And he understands that he would have to come back either the 14th or 20th.
Okay, got it. So you think between now and the 14th, you'll have sorted some of this out?
That's my goal.
Okay, excellent. That we can do. Do you need Mr. Christmas to stick around anymore? All right, Mr. Christmas, you have good contact information for Ms. Wood? Great, thank you for being here. You're free to go. That gets us to Mr. Henley.
Please.
All right, Mr. Henley, come on up to the podium, please.
Okay. Yeah. Oh, yeah, no, absolutely.
Just read it, right?
Okay.
Mr. Henley, you slide over one. Thank you.
Oops.
Ready? Ms. Wood, are you ready?
I'm ready, Judge.
All right.
It's just the indictment.
Ms. Rivers, are you ready?
Yes, I'm ready.
Great. Let's go on the record. This is 22 SC 182594, State versus Brian Henley. Mr. Henley is here in court with Ms. Wood. Ms. Dilligard is representing the state. Good morning, Mr. Henley.
Good morning, sir.
Good to see you again.
Yes, sir.
Mr. Henley, Ms. Wood tells me you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Ms. Dilligard's going to put you under oath in just a moment, ask you a bunch of questions. Please let me know if you ever have any questions about anything we're talking about, okay?
Yes, sir.
All right, Ms. Dilligard,
Judge, can I have actually 1 second to ask Lacey a quick question?
you may.
Well, I hope it's not the same thing I'm looking up. What? The license plate? I think so, but I was just trying to confirm that it's not on the little cheat sheet. Okay.
Okay, cool. Okay, cool.
We're good?
Yep.
All right.
Okay, Mr. Henley, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true and correct legal name for the record.
Brian Jeffrey Henley.
Mr. Henley, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 48 years old. I went to graduated high school and got a few years in trades.
Do you understand that you've been charged with the following offenses? It's 1 count of possession of firearm by convicted felon and a count of driving expired or no license plate or decal.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent or refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the charges in the indictment, including the facts and circumstances related to those charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
Not at this time.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
So wait.
Mr. Henley, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For the possession of a firearm by convicted felon, the range is 1 to 10 years. And for the expired or no license plate or / decal, the range is 1 day to 12 months.
Yes, ma'am.
I didn't hear.
Yes, ma'am.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. Judge, the recommendation on count 1 is 5 years suspended, and on count 2, it's 12 months probation. And then the only condition is to forfeit interest in the firearm.
So it will be misdemeanor probation. And do the 2 counts run concurrently with each other?
Yes,
Okay,
yes, and yes.
okay. I don't think I've ever had a sentence like that. Interesting.
First time for everything, Judge.
Yep, I like learning new things.
Is that your understanding of the recommendation, Mr. Henley?
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if there are multiple charges which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
If you want to offer it.
So we were going to do an offered plea on count one only, Judge.
Okay. You were or you are?
We are, I
Okay.
think, yes.
Yeah, okay. So are you pleading guilty to count one because you've decided that it's in your best interest to do so?
Yes, ma'am.
Mr. Henley, how do you plead to the charges of possession of a firearm by convicted felon and driving expired or no license plate in indictment number 22 SC 182594?
Oh, I'm pleading guilty in my best interest.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And you understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the evidence would show that on April 8th of 2022, officers initiated a traffic stop on a test drive license plate. They identified the driver as Mr. Henley. After performing a check on his information, they found that he had an active warrant out for his arrest. There were 2 additional passengers in the car, a female in the front passenger and a male in the right rear passenger seat. They were informed that Mr. Henley was being taken into custody. When they inventoried the vehicle, they found a firearm underneath the driver's seat, but like pretty much in the back.
So sort of at the feet of, if someone were sitting behind the driver.
Yes. The 2 additional passengers were, they were asked if the firearm belonged to them. They said no, they let him go. They didn't get any information or anything like that of those additional passengers. And that's pretty much it. All of that occurred in Fulton County, Georgia, Judge.
All right, thank you. Ms. Jackson, do you have any criminal history information for Mr. Henley, please?
Yes, Your Honor. He has 18 cycles. The last arrest was April the 6th, 2023 in DeKalb County for criminal damage to property in the 2nd degree. There was no disposition for that arrest. And he does have felony convictions. There's one in 2016 out of Gwinnett County for possession of methamphetamine. And there was one in 2002 out of New York for possession of controlled substance. He does have misdemeanor convictions. There's one in 2021 out of Bartow County for possession of marijuana less than an ounce. There's one in 2016 out of New York for petty larceny. There's one in 2013 out of New York for misdemeanor possession of controlled substance. One in 2012 out of New York for possession of controlled substance. There's an additional one in 2012 out of New York for petty larceny. There's one in 2011 out of New York for possession of controlled substance. Nothing in addition, Your Honor.
Thank you. Ms. Wood?
Thank you, Judge. So I believe this was in the diversion track when it went through drug court, and that's how it ended up here?
Yes, ma'am.
Okay. There were multiple passengers in the car. There would have been an argument to have been made at trial. Mr. Henley, though, is ready to move forward. This is a case from 2022. He has been a model client. I'm hopeful that, and I'm pretty confident I won't see him back here, Judge. So we would just ask that you accept the state's recommendation.
All right. Mr. Henley, what's new with you?
Still working, yeah.
Doing what?
Still with the maintenance, Cushman and Wakefield.
Good.
Still got Rihanna. Teresa still is. She work at UPS at the, the UPS that a lot of people got the jobs at.
Yeah, the big distribution
Fulton
center.
County. Yeah, so she's there now.
So you guys still living together?
Yes, sir.
Good. And dog's all right?
Yes, yes, yes.
Okay.
yes.
And how about your health? You taking care of yourself?
Yeah, I've been losing weight a little bit,
You look a little skinnier when you came
Yeah.
in,
I've been,
but it's like good weight loss. It's
yeah,
not like,
I'm more active. I'm working. It's not a lot of sit down time with me. I get a lot of. I'm a lot of more motivated. You know what I'm saying? I'm doing a lot more. With the freer time, stuff like that, trying to keep my time a little occupied.
you meaning you don't have to go to drug court all the time? For your time, I see. All right. I'm glad that the lady's still in your life and the dog is still in your life. Are you off sleeping on the couch?
Yes,
You've been taking off that probation.
Yes.
Good. Okay. All right. Well, Mr. Henley, anything else you want to add?
Not at all, sir.
I find there's a factual basis for your plea. I understand why it's an Alford plea as to the gun. Kind of an equal access argument, but I also understand why you've decided it's in your best interest to move forward with this and get it in your rearview mirror. So I'll accept the plea. I also find that your plea is knowing and voluntary. No one's forcing you to do this, and you understand the consequences. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And Mr. Henley, can we electronically put your name on the plea?
Yes, sir.
On the indictment indicating your plea? All right. Count one is an Alford plea. Count two, the misdemeanors are plain old guilty plea. Your sentence as to count one is 5 years. Those are suspended. There is one condition to your suspended sentence, and that is that you obey the laws of Georgia and the other 50 states. All that means is if 2 years from now you get arrested somewhere and the state learns about it, they could bring you back here and say, Judge, you should revoke some of that suspended sentence.
Okay.
You're not on probation. No one's supervising you other than if you get arrested and word gets to the state, we could do something about that.
Yes, sir.
Count two, the misdemeanor, will be 12 months of misdemeanor probation. And the only condition of your misdemeanor probation is that you forfeit whatever was seized that day. You've already not had it for a bunch of years, but you don't now go back to whatever police agency it was, like, hey, go into evidence and there's a gun, you need to give it to me.
Oh, no.
That gun is gone. My guess is it's already been bent into artwork somewhere, but don't try to go get it.
Yes, sir.
And if you have had no issues on probation after 6 months, then you're welcome to reach out to Ms. Wood, to have her reach out to me to see if I would be willing to end that probation early. You'll be paying a little bit, and it's probably going to be telephonic reporting. And again, it's not felony probation, it's misdemeanor probation, which is through a private company. So it's just a different format.
I do have one question.
Mm-hmm.
After this goes through, do I still report to pretrial?
No.
Okay.
Nope. You'll have a different reporting responsibility.
It's still a report, but I mean.
But it's
aside
through
from
misdemeanor probation. It's not the same people.
Okay.
It'll be probably less frequently. But then you're also paying some monthly supervision fee.
That's fine.
Okay.
Yes, sir.
And Ms. Wood will be probably hearing, is that how it's been working recently? You and Ms. Rios are the ones who get the contact from JCS?
Yes.
And then you reach your client.
Yes, I submit everything on his behalf.
Got it. So Ms. Wood will be letting you know, here's who to call or where to go online.
Yes,
You need to do that because I'll know she got that info. And then if I am hearing from probation saying, we never met this Henley guy, I don't fuss at Ms. Wood. I fuss at you. Okay? Any questions about any of that?
No, sir.
Ms. Dilligard, anything else?
Nothing further, Judge.
Ms. Wood?
No, Judge, thank you.
All right, Mr. Henley, good luck with things.
Thank you. Thank you so much.
You're
You
very
bet.
welcome. The
You'll be
pleasure was
reaching out to
mine.
me.
Yes.
Sir, I know I didn't get a start today, but can I get one of your candies?
One.
Yeah.
All right, yeah. Have a good day.
You bet.
Honestly, I don't have anything more to say right now.
Nope. Why don't we take care of, why don't we get on the record, the Mac Ransom thing, and then you can go. And that'll make my Ms. Powell situation easier if you're not here. Give me 1 second. Okay, Mac Ransom. All right, Ms. Rivers, are you ready to take down something that wasn't on your calendar if I give you the style of the case?
Yes, I'm ready, Judge.
Great. This is 21 SC 180102, State versus Mac Ransom. Mr. Melnick is here in court on behalf of Mr. Ransom, who is in custody somewhere.
County jail.
Just not brought over today because it was supposed to be tomorrow morning. Ms. Dilligard is handling things for the state. And Mr. Ransom faced a revocation. I signed a probation warrant relating to or arising out of an arrest in Early County, which I don't know if that's his residence, but he has lots of business down in Early County. It's not the first time we've been dealing with Mr. Ransom and Early County. Why don't you go next, Mr. Melnick, and then I'll hear from Ms. Dilligard.
So Judge, the basis for the revocation was an arrest in Early County. The charges were ultimately null pros. It was after this warrant was issued, the charges were null pros in February of this year, but a null pros has been entered in Early County for the theft by taking and the criminal trespass. So Mr. Ransom has been in custody for roughly 90 days. And the agreement that we have is 90 days to serve, credit for time served, obviously, and then return him to probation.
Okay. Let me just pull up his case. Hold on. Okay. Is there anything else holding him in? There's something that says Foreign County on his booking screen.
It's a traffic ticket out of East Point.
Okay, so he'll go there next and deal with that.
Yeah.
Okay. Ms. Simpson, how much time remains on Mr. Ransom's 21 SC case? Oh, this wasn't on your calendar for today either. So while you're looking that up, Ms. Dilligard, one more thing for Mr. Melnick. Mr. Melnick, Mr. Ransom is not here. If you would put on the record the waiver and authority he gave you to proceed in his absence.
Your Honor, I spoke with Mr. Ransom yesterday and I told him what the situation was, and he has authorized me to make this announcement and enter into this agreement on his behalf.
Got it. That's what we'll do. I don't know that that's the agreement, but we will proceed with him not here. Ms. Dilligard.
Judge, the Early County theft by taking, just for the record, was no pros, but not because it wasn't Mr. Henley or because he wasn't there or they had the wrong person. It was no pros due to a negotiated plea. So he pled to another case and the negotiations that they would no pros that case.
The other case he pled to just wasn't on the probation warrant?
It was on your earlier probation warrant that he already had.
Oh, that he was already revoked for?
Mm-hmm.
Okay, also something in Early County.
Yeah, it was a deposit account fraud.
All right. Good old Mr. Ransom.
Mm-hmm.
Okay. Go ahead.
With all that being said, we're fine with the 90 days that he has spent already. So that's the recommendation of the state.
Okay. How much is left on that probation?
He has 3 years, 9 months, 27 days.
Okay. I was asking only because if there wasn't a whole lot left, maybe we just close it out. But he has not done super on probation, and so I'm comfortable keeping probation wide open.
Yep.
And has he been supervised down out of Early County or whatever jurisdiction?
Yeah.
Okay.
My understanding, he has, because I actually spoke with the probation officer down there. So yes, he has been supervised in Early County. They have one probation officer for the entire county.
Excellent. Well, you know who your officer is.
Yep.
I will, in light of the arrest in Early County for the theft, revoke 3 months of Mr. Ransom's probation. He'll get credit for time served from January 3rd of 2025. That's when he was booked in here. He might have done more than that. I don't know where he was arrested. If it was down in Early, he had to get up here, but I don't have visibility into that. However, if he gets credit from January 3rd, he can check off the 3-month box immediately. So we'll do that. And we'll reinstate the balance, and I'll ask that he remain on supervised probation for at least 2 more years. I know there's an area on the new revocation order to indicate it doesn't need to be supervised anymore or at DCS's discretion, but I want at least 2 more years of supervision. I know there's more than that remaining on his sentence, and they may choose to supervise him the whole time, but we'll keep eyes on for at least 2 more years. Mr. Melnick, anything else on behalf of Mr. Ransom?
There you go. Thank you.
Ms. Dilligard?
Nothing further, Judge.
Okay, then you guys don't need to be here tomorrow morning for Mr. Ransom.
Thank you.
And you're free to go, Mr. Melnick. All right, I don't know that we have, other than waiting on Ms. Gladden, anything we need to do. Have you been able to talk with the people you want to talk to?
Yes, sir. And Ms. Favors had a family member here, so I was gonna let her see the court today.
Sure.
So free to bring her out.
All right. Before we bring her out, I'm gonna let her know that she's third in line with us, just to manage her expectations. Because we've got Dandridge and the surprise emergence. Mr. Dennis seemed pretty hot to trot, and Mr. Bass was like keeping up with him in the conga line. So I don't see that. I don't see us reaching Dennis before Favors, unless something real funky happens. Or it could be, as you learn more, Mr. Abate, that there's just not a way to move forward with the Dennis case because of witness availability. But I suspect we'd do Dandridge and then we would do Dennis. I'm just trying to think through. Okay.
She's also on the Emerson calendar.
She is, but I'm not going to have Mr. Abate go back to back to back. I try to avoid back to back, but she is there. I just might have to eat that one if Dennis goes forward. I mean, there's always the chance that Mr. Dandridge changes his mind, but boy, that seems remote.
Yes.
All right. Good morning, Ms. Favors.
Ms. McBurney.
It's good to see you. I want to let you know where we are in the process of trying to get you your trial.
Yes, sir.
Because I know you're anxious to get that moving. You are number 3 in line. I have 2 murders that are older cases, meaning those defendants have been in jail even longer than you. And I'm going to try to take them in that order. I only have 2 weeks of trial calendar also. So for this month, not for the rest of the year. It may be that you get brought over one of the 2 weeks. It's not next week, but it's the week after and the week after that. But your case would be a backup to one of the other murder cases. Ms. Wood will keep you posted on that because things can change. Someone can plead, or a lead detective might be on leave that we didn't know about. And so we can't go forward with one of those cases. And then yours would move up. Your case is also on what we call the consolidated trial calendar that a different judge handles. So we can try to move more cases for people who are stuck in jail. And so that's a second possibility of when it might be reached. I'm much further down on that list than you are on my list, because there are a bunch of judges who send cases to that consolidated calendar. And it's also only 2 weeks. So they don't get to my case till they get to a bunch of other cases. But there's still another chance that we could get your case in front of a jury, which is what you've asked us to do. So I just wanted to give you that update. Ms. Wood, was there anything else we needed to cover?
No, Judge.
And still no discovery issues you're aware of?
No, Judge.
All right. Are you ready if Ms. Favors is what we end up doing week 2 instead of the case that's ahead of it?
Yes, and we're gonna keep talking with Mr. Abadi, but we'll be ready if needed to be.
Okay, sounds good. Any questions for me, Ms. Favors?
No, sir.
Okay, all right. Well, we will see you soon.
All right.
All
Yeah,
right,
thank you, Judge.
you bet. And someone really wants you back there. Oh. He's a vocal guy. Jurors aren't gonna think he's a real safe guy. Okay, interesting. Anything else? I think we're gonna hold for Ms. Gladden. So if you don't mind doing whatever you do on your laptop. But otherwise, we're good, Mr. Abadi. I'll get an email out, but it's looking like Dandridge for the week of the 14th. And if you wouldn't mind having your team reach out to your key witnesses on Dennis, just so I can have an early heads up if not able to go, and we'll just need to figure out, does that mean Favors moves up?
I'll work on that today.
Thank you. All right. One last thing. Any concerns or feedback about that equipment that was down in 1D?
No, I mean, it worked most of the time pretty well. And the best part about it was the sound was good and the video lag was almost not.
Okay.
Very few times that it had to catch up just a little bit.
But it was a little bit as opposed to what we see here.
Leaps and bounds.
Okay. I know one thing that didn't work for a minute, and it may have been you who told me rather than Judge Emerson, that the touch screens weren't working, and then all of a sudden they kicked in and there were 400 circles on the screen.
That happened a couple times, but it was very minimal.
Okay.
So I mean, it was better than the normal circumstance, I'll be honest with you.
Okay, good. Well, it ought to be. It's newer equipment. I mean, we ought not to replace this with something that's worse.
When we connect, you're good.
Don't you just put an HDMI in?
Much better than everyone being on the Zoom.
Yeah, yeah. Well, and that's what's supposed to have eliminated the lag, is that it's sort of like when you plug it into that monitor there, it's just whatever delay occurs in the cable. And longer term, there won't be these clunky monitors on wheels. There'll be stuff mounted, so it's not obstructing views.
It was much better.
Okay, good. Sadly, it'll take months for it to get into the courtrooms, but at least we're moving in that direction.
I was gonna say years, much better. Projection.
Mr. Perry, you raised your hand. Did you have a question? What's that? Say that again?
Joe reminded about the dead marshal.
Okay, well, let's have Ms. Gladden here for that, okay? Wow, Mac Ransom already done.
Moving over here.
Yeah. So I will come back out once Ms. Gladden gets here. I guess you're done?
I'm done.
Okay.
Yes. So, the wrong way.
Hey, if Ms. Powell shows up, she's going in. We'll do a bench warrant for Lim. He wasn't gonna show up anyway. But Powell still might walk in, and then she's our guest. I'll make sure we get that rolling. Thanks.
Yeah.
So that's what.
A.B. Miller and Garrett Rolfe.
Yeah.
Yes.
I have posted the last meeting.
Yes, and that way, hopefully she gets
I think it was
just
wrong.
remote her into PhD.
So, okay.
I'm just burning out. Yes. Okay. Thank you. Appreciate it.
By the name sounds right.
Yeah. I can probably get you in touch with him. He's called someone.
Amina has tried to reach out a few times while I've been in court, but let me see what number.
If for whatever reason.
Hey, did they put down?
Yeah, here's a number. I'll just shoot it to you.
Okay.
Cell phone.
For now.
In my bag for 2 weeks. And I have
For now, I'm good.
Like a year, like a for the work.
What's up?
What's up? Thanks, Roger.
Look at that. Hey,
Hi, Judge.
um,
I'm sorry. Sometimes when an attorney tries to decide where they should go, they make the bad decision.
I don't need to make a bad decision. We're still going. I mean, it was a call with a
But
calendar.
I just have to apologize to you profusely. I'm so sorry.
Okay. Why don't you and Ms. Dilligard talk for, unless you've already spoken, I just need to get an update. Mr. Perry's on for trial and, I'm ready to give him a trial on home invasion, aggravated assault, all that stuff.
Yes, Your Honor.
So if you two want to talk, you can talk for a minute, and then I can come back out.
Yes, Judge, I do have a letter. I fell down my stairs at my house in late October
Mhm.
and then fell 3 more times. And so my doctor, I fractured some of my spine. And so a lot of things are easier to do, but I don't know that I could do a full-blown trial right now. I can only stand or sit for certain periods of time. And it might be disruptive, especially when there's probably going to be as many witnesses. So I would just ask to put, you can even make this first step on the next calendar, Judge. I just don't feel that I can properly, or at least completely effectively represent my client right now, because even now, my back started hurting. So, but I'm getting physical therapy finally. And so it's getting better. It's the first time I've really been injured. So I didn't know much about recovery times. So I'm respectfully requesting that the court, I'm assuming they want to try both cases. He and his.
She was here. Ms.
Yeah,
Taylor had a
Ms. Taylor.
conflict, so Ms. Hightower's gone.
Right. I'm not sure what Ms. Taylor's announcement.
She wasn't here. She had leave. So there was no announcement from Ms. Taylor.
Oh, okay, Judge.
Why do you think that in a month you'll be better? What you're working through sounds like it could be chronic. And I want to avoid a situation where each month it's, I'm still in physical therapy. And Mr. Perry has the right to counsel of his choosing, but of course, the state has a right to have cases move forward. So I'm all right, especially since Ms. Taylor was unavailable, bumping this once. But I worry that what you're working through isn't something where you magically wake up in a month and say, I'm pain-free, I can be on my feet. There will be a bunch of witnesses. There are a bunch of victims in this case.
Right, yeah, as well as witnesses on both sides too. Your Honor, I think what I can tell the court is when I first fell, I fell and then I woke up. I was very much concerned more about the concussion and how it would affect me mentally and my ability to think, of course, as a lawyer on behalf of my clients.
Right.
So I waited 2 months before I went to the doctor about my back, because I just thought, oh, my back's aching a little bit. You know, I've worked through worse. But however, once I went and I found out what was wrong, and that was in December, I've been going to physical therapy 2 or 3 days a week. So I'm due to go back and see my doctor in April. And I assume that I will be kind of released. It's just I put off my back situation, and that's why I'm pretty confident, because it has been getting better with the exercises. you know, I will do what I have to do. I don't take any pain med, Judge, other than a leave, or I don't have any like prescription pain medications or anything like that. So it's not a situation where, again, now that I'm more confident about my mental capabilities, I'm sure that I could say things. It's just right now I do have kind of a time frame, but I think in a month, because it has come so far, and I will be seeing my doctor hopefully I do have a letter for Your Honor. It just talks about it. I would like to think that I would be fine by then. You know, again, had I addressed it early on and known that I'd actually fractured something in my back, I would have addressed it sooner than I did.
Okay. Ms. Dilligard, is it the state's preference to try Ms. Hightower and Mr. Perry together, or because of statements made, you were going to have to separate them, or what's your outlook?
At this time, it's our preference to try them together.
Okay. All right. Then Ms. Gladden, I will reset this. I had to reset it once. I had to reset it for Ms. Hightower because of Ms. Taylor's leave. But if the state's not interested in severance, at least for one cycle, I won't sever, because if we can't go forward with Ms. Hightower, your client's on bond. And so another month, I'm okay with for now.
And Judge, I was just asking if my client still had his ankle monitor, which this is not involving my case, but we did discuss it briefly. Thank you so much for getting back in touch with me about your preference. I had emailed you back to try to get some direction on why you didn't want to take it off, because he's had it on for 2 years, Judge.
Right. And he brought that up before you got here, wanting to be sure we'd cover that. And I'm trying to strike the right balance. He's been wearing an ankle monitor for longer than is normal. But there also have been some recent situations that make me think keeping the ankle monitor on is probably smart, especially if trial is just around the corner.
Absolutely,
if we were just here for arraignment and all right, we'll do trial in 9 months, we might need to revisit that. But I think for now, we're going to maintain the status quo. If you hear back once you get into physical therapy that it could be a number of months that you won't be ready, then we might need to
I will bring
revisit.
in other counsel, Judge.
Okay. Then we could talk about the ankle monitor. Okay.
Oh,
yes,
and
sir.
another step too.
Mr. Perry.
I'm sorry. There he is, Judge.
You had your hand up. Was there something you wanted to add?
Yes, I want to speak. That I have lost business. I have a landscape business, and every time I get a client, like especially a Fayetteville, and they see the lead monster, they never call my business back. My business have trending all the way down because of the lead monster. When I enter the people yard and they see my lead monster on, they never call it back. They never call me to cut their yards or trim the trees back again. It's been like that for the last since I had it on. And like now I went from $500 yards, $600 yards to $75 yards. Because Fayetteville and Bucket, they pay more of those houses than down south.
Sure, but they won't take you when they see the ankle monitor.
Yes, I went from a 6-man crew to a 3-man crew because the prices of the yards and I couldn't pay them. And so it's really done trend me all the way down. Because people see lead money, I guess whatever they give them the idea of, they never want you to come back on the
I understand. I could see why someone would do that. Ms. Dilligard, is there something you want to be heard on in terms of the ankle monitor? I hadn't heard from Mr. Perry about the financial impact. I know it's not fun to be wearing one in general, but he just helped me understand the impact that it has on his work.
Judge, the state's position, I think there was 2 concerns from the state. There was a new incident that happened with a family member that the state had concerns about, and then also a condition of his bond was to stay out of Fulton County, and the state had reason to believe that he's in Fulton County because this incident happened within Fulton County. And
all right, but I thought I had modified the bond to let him be in Fulton County.
I thought I only
Maybe
saw
not.
for purposes of there was very specific purposes, like,
Is that the bond in this case or the other case?
Judge, I do know that the ankle monitor is required in the other case, in another case.
Okay.
But and I believe, and I don't mean to misspeak, but this is apparently a family argument situation, not anything or any allegations that he had contact with the real victims in this case, which he actually doesn't know where they are. But, and I think there's always two sides to a story when you have a family.
Sure. I hear you on that.
Ask my daughters. Send you some phone numbers about the family situation. For you to talk to.
The victim? Are you talking about the?
It's not him, but it's people that were there when this incident actually occurred. So, yeah, okay, thank you. They were having a family meeting and she shows up and pitches a fit and then she calls his probation officer the next day. So these are just people that can confirm the facts as alleged by. I like it, Jackie.
Thank you, I appreciate that.
Not the George you're looking for. Again, I'm so sorry. Well, it's not okay. You got plenty to do. You got a lot of work to do.
All right, he got his two bonds at the same time. So that's other than the dollar amount being different, the bonds in the two cases are the same. There's a curfew. I mean, there's a different stay away. But it's a curfew and stay out of Fulton County except for court and attorney visits. And apparently there was some story about needing to transport parents and grandparents. And those were allowable as well. That was 2 years ago, plus a couple months almost now. Tell me, Ms. Dilligard, I know there was a bench warrant at one point because he missed court, but that got cleared up because he actually ended up not getting notice. He had moved or something. I mean, that's already been litigated. Other than the situation to which you were referring, that Ms. Gladden is calling the family dispute, anything else that makes you think keep the ankle monitor on?
No, Judge, I've reached out to the victims. They haven't had any issues. Their stance is they would like the ankle monitor to be on because they still live in the same vicinity. And even though he's not supposed to be in Fulton County, he has been in Fulton County creating some havoc. And so that's the state stance, but we'll leave it in the court's discretion.
Okay.
And Your Honor, my only argument would be this, as you pointed out, this case is 2 years and several months old. Living in the vicinity could mean a lot of different things. My client has no knowledge of where they live. This was a rooming house, if that makes sense, where people pay by the week. And this involved his attempt to evict him. which I won't go into details
Good.
more than that, but as far as that goes, they moved out the same day. And he has no idea where they are, if they are in the vicinity, Judge. And I think if he were going to try to in some way intimidate them, that he would certainly have done something before 2 years and several months.
So what I'm going to do is take a graduated approach, and I will modify the 2 bonds by lifting the Fulton County restriction and leave the ankle monitor on. But we will revisit that if for some reason the state isn't ready the next time we call this for trial. If the defense isn't ready for whatever reason, that's something that Mr. Perry can be frustrated with his lawyers about. But I will enter an order modifying the bond that lifts that curfew so that he can be out and about working. And if that work takes him into Fulton County, that's okay. But that'll be step 1. If there are not issues with that, then we can talk about taking the monitor off if the state's not ready for trial on the next calendar.
Thank you, Judge.
All right.
And again, I apologize. And next time I'm gonna be in your courtroom, first of all, no matter what. And
All right.
But thank you so much, Judge, for your understanding, and I do appreciate it.
You
And I
bet.
hope you have a great rest of your day.
Enjoy
and-
the candy.
And may I be, oh, I did, you saw me sneak it, this is not the droid you're looking for, right? But may I be excused, Your Honor?
Yes, ma'am.
Thank you, Judge. I told my client, like, you're probably gonna have to bail me out of jail. I'm gonna go over it. And I have some business for you to go to. Thank you, Judge.
You go to
Yep. Thank you, Ms. Jackson.
Thank you, Judge. Have a great one.
You too. Thanks, Ms. Rivers.